Good evening, everybody. On behalf of the Tamil Nadu Mediators and Conciliators Association, I welcome you all to the fourth talk show in the series of talk shows organized by the association to learn about community and court mediation in different countries. The Tamil Nadu Mediators and Conciliators Association is a non-profit organization formed with the objective of promotion of mediation and exchange of information about mediation and other ADR methods. The association has organized several awareness programs on mediation. It's an honor for me to have the opportunity to introduce our distinguished guest for the evening, Mr. Abe Quadan from Sydney, Australia. Abe is a nationally accredited mediator and an accredited family dispute resolution practitioner with over 37 years of experience. He's a skilled mediator with vast experience in the areas of workplace mediation, employment dispute resolution, family dispute resolution, and general dispute resolution. Abe was a lecturer at the University of Sydney, teaching mediation, theory, and practice to students of the Master's Program in Peace and Conflict Studies in the University of Sydney. He's a conflict resolution practitioner, facilitator, and trainer. He believes that conflicts should be resolved peacefully and is passionate about peace with justice, human rights, democracy, and equality. Abe has facilitated several conflict management workshops for community leaders from Sri Lanka, Congo, Uganda, Rwanda, and Burundi. He's the co-founder of the Palestinian Jewish Dialogue Group in Sydney, Australia. He is the initiator of the Youth Peace Initiative, Sydney Peace Foundation, and has served as an executive member of the foundation. He is the vice chair of the Cambodian Mediation Center Board. As you can all see, Abe has a rich and varied experience in conflict resolution and conflict management and mediation, and I'm sure all of you are looking forward to his presentation today. The format for this evening's program will be like this. Abe will have 45 minutes to speak and make his presentation. This will be followed by a question and answer session. So I request all of you to hold your questions, if any, until the completion of Abe's presentation. After the Q&A session, Ramamani will deliver the vote of thanks. Over to you, Abe.
Thank you very much. And I thank the Tamil Nadu Mediators and Conciliators Association for inviting me and providing me with this forum. And I thank you all who are present in this evening to share with each other our experience, knowledge about mediation. And I think we are all passionate about it, and that's why we are here. What I'm going to talk about tonight, I'm going to talk about the history of mediation in Australia. And in particular, I'll be paying special attention to community mediation, that the government service that provides to the people of Australia, and the rationale, the philosophy behind it, and why we do it. And I believe that in India, there is a move or an interest in community mediation, considering that you have the court system is completely clogged with cases and the waiting time is so high, and mediation could be the answer to this problem, as well as there's so much cost and involved with court cases. So it is something that maybe you will find interesting in adopting or pushing for adoption in India as well. And I'll just talk about our experience with mediation and community mediation and how does it work. And I will not be taking the 45 minutes to talk, because I'd like to have more question and answer so we can have more discussion with each other and give you more time to really speak out and say whatever you want to say. When I applied for mediation, for the job as a mediator back in 1983, it was the first time that mediation was offered in Australia. for formal mediators. At the time, there was mediation in Australia before 1983. However, it was very private and it was not widespread. The Community Justice Centre was established by the New South Wales government, and it is a department or an office part of the Justice Department. And they had imported that system from America, the community mediation in America. So I'll be talking about it, and it's interesting to see the evolution of mediation since then. First, I want to start with mediation is a process which an impartial third party who has no authority to impose an outcome, solution, assist the parties in a dispute to resolve their conflict. Judge Joe Herman, in a speech to the National Mediation Conference in 2014, said, historically, Australia has been among the most litigious societies in the world. We used to love and do everything, take things to courts. The burden, financial and otherwise, on litigants was severe, both costly to the community as well as individuals, plus to the system. The public money spent was severely strained by the necessity of allocating huge resources in terms of infrastructure and personnel, judges, juries, facilities, and support staff to the hearing of all these cases. In the late 1980s, the courts decided that the days of litigation being conducted at whatever leisurely pace by the protagonists shows it was over. Case management became the weapon of choice of the judiciary in its quest to confine cases to real and relevant issues and compel litigants to conduct litigation quickly and efficiently. Compelling parties to settle disputes and those cases that should be settled as early as possible and to seriously address issues of resolving the more challenging disputes were both philosophies at the center of the case management drive. It is no accident that the rise of mediation in Australia coincided with the rise of case management and its underlying philosophy. Now the courts and the parties are very much focused on alternative resolution, with mediation in the forefront of that push. In the mid-1970s, Australia transitioned from being dependent on the court system in resolving conflicts to incorporating alternative dispute resolution models. It was acknowledged then that litigation is costly, time-consuming, and not fair. Litigation does not favor people without financial backing. The poor will never be able to have a case in the court because of the cost involved in taking matters to court. At the conference, Judge Joe Herman noted that the emergence of a new, more affluent society and the middle class tentatively entering the previously privileged domains of the elite saw greater volumes of commercial, real property transactions and such disputes. And this is because the population in general, there's improved financial wealth. There's the wealth, the distribution of the wealth among the people, which is created the middle class. Workforce fueled greater social freedoms and more liberal attitudes. Non-traditional commercial transactions. It's no longer between businesses or corporates and whatever. Ordinary people are entering into commercial transactions. Exposure to non-Anglo cultures and practices. Workplace disputes because of the unionization of the workforce. Land rights by the Aboriginal and indigenous communities, as well as the multinational and complex commercial disputes. Add to the above, the election of a Labour government who introduced considerable number of social reforms, including the no-fault divorce under the new family law legislation. The new social and legal reforms introduced by the Labour government in 1972 to 1975, and the emergence of the affluent middle class and the indigenous people's demands for land rights warranted a new approach to resolving disputes. Litigation was seen ill-equipped and not suited for disputes that have individual or a group interest. Australians value relationships. Litigation is seen, and in the majority of cases, is destroyer of relationships, or at least damaging the relationship between people or the litigants. On the other hand, mediation is seen, and in majority of cases is a relationship builder between parties in conflict. Ulrich Magnus said, next to the United States, Australia has become the global forerunner in mediation law and practice. Mediation is officially seen in Australia as a preferred, cheaper, and a quicker alternative to traditional court litigation. There are a great number and variety of legislative acts providing for mediation, partly enable courts to order mediation procedures against the will of the parties, partly requiring parties' consent. Outside the courts, a whole mediation industry has been established with many private organizations and institutions offering mediation services for any kind of disputes. Rather recently, National Practice Standards and the Quality Assurance Organization has been set up to try to safeguard and increase the quality of mediation services and the qualifications of mediators to preserve the integrity of the profession. Australia is well known being a nation of early adopters of new technologies and systems. Australia adopted the American model of mediation in the late 1970s, early 1980s. The Australian courts were quick in adopting and incorporating mediation into the court system. In 1983, the Victorian County Court Building Cases List made provisions for matters to be referred for mediations to resolve the cases. Some courts have mediation or mediators positioned within the court building in the courthouses. Courts have the option of litigating a case or referring it or part of it to a mediation. The court would convene, ask the litigants to go to mediation first and then come back. And they will adjourn the case until the mediators have done their job. So it is recognized as an integral part of the court system. It's not something outside. And this is a very, very sort of a huge step towards recognition of mediation within the court system or the legal system. The Australian federal government has set aside a budget to finance organizations and institutions who offer mediation services at low cost to people who are financially disadvantaged. The Family Law Act makes mediation compulsory for couples seeking divorce. They have to go through mediation first before they being heard in court. Early days of alternative dispute resolution in Australia were not easy and faced many challenges from many lawyers and to some extent from the public. This was due to the fact that not many understood the role of mediation and its ability to resolve disputes, because we had the mindset that only courts can resolve my issue, nobody else. Many questioned the ability of a mediator with no formal qualifications, legal or otherwise, in resolving complex matters. This view compounded by the fact that mediators have no authority to impose a solution. Another skeptical view was the ability of a person with no qualifications to resolve dispute within hours in one day, while it's the same case could take legal practitioners, lawyers, months, if not years, in litigation. It is a fact that mediation posed a great threat and challenge to the legal profession in the early days of the 1980s. The lawyers seen it as a threat to their jobs, to their work, to their taking cases away from them, and all of that. And they actually challenged the system and cast doubt about its ability to survive within that system. It is worth noting that since then, the great majority of lawyers have mediation accreditation, and many shifted their practice from litigation to mediation. And I'll give you an example. Back in the mid-90s, we advertised for 26 positions of mediators, and we received 500 applicants. 300 of those applicants were lawyers. And that shows the extent where lawyers accepted that this is an important thing to have and important aspect of their work to have a mediation degree. And the 300 of those applied for the jobs were lawyers. The New South Wales Law Society, which oversees the ethics and the interest of lawyers in New South Wales, encourages its members to advise the clients of the advantages of mediation through the publication of guides and codes of practice. So they are actually encouraging their customers, those especially with low income or cases could be managed by mediation, to refer them for mediation. And many of the law houses, the legal practitioners, they do have mediators within their practice who can take those cases. So they're actually not losing. They still have the business, except they are using mediation instead of litigation. The law societies in Australia, except in the Northern Territory and Tasmania, offer dispute resolution services and/or maintain a register of approved alternative dispute resolution practitioners. In the early 1980s, they were indeed very challenging to alternative dispute practitioners. The New South Wales government established the community justice centers in 1983. And the purpose of the centers was to offer free mediation in community and neighborhood disputes. The range of disputes were soon expanded to include commercial, family, marriage and divorce, and workplace. The program was a great success. This success was noticed by the courts and police. The courts had less cases than they used to have before the establishment of the community justice centers. And police did not have to attend to as many disputes as they used to. There's a huge drop on the cases, and the police had more time to attend to serious cases than smaller cases. The Community Justice Center, what they, just briefly, I want to give you how they work. There's a director and a few people working in the office. They recruit mediators who qualify with certain characteristics. It's not about the qualification, it's about the personalities and their ability to work with people and be able to be impartial and neutral with a good depth of insight into the human interactions and relationships. And they recruit them and they train them. And once they're trained, they are paired with experienced mediators, and they work together to gain experience and knowledge. It is well-known fact that mediators from the community justice centers are leaders in mediation, or were the leaders in mediation in its early days and beyond. And they still do operate at that level. They're highly qualified and highly experienced and highly knowledgeable, and they produce between 85 to 90% success in mediation. The parties don't pay any, it's free to the parties. And the reason, and the mediators get paid by the centers. But the mediation itself is free and it's open to anybody. There's no screening, there is no means test, like if they can pay or not. We don't ask those sort of questions. We just offer it free to everybody, because the alternative is for them to go through the court system. And we don't want the court system to be clogged with so many cases. So it is that reason we do it that way. And it is working really well. And they have offices in every part, in every city in New South Wales. And they offer, and they still offer it now through Zoom and other means because of COVID. But this is how the centers work. And they have, and they're not, the people who are working with the community justice centers, they're not there full time. So if you choose to work full time, that's fine, but they're not there full time. They are called whenever they are needed. They still have their own jobs, normal jobs, or the other things they do. And when they are needed, they can call them and they can do it on the day they are called. And they work from either the courthouses or from offices of the community justice centers. They have special offices and the court cases as well. And some of those mediators, they have a roster where they are actually in the court, in the local courts, sitting there waiting for cases to be referred to them by the magistrate. So it's a system that works and encouraged by many. There's the other part of the other service, which is free, is legal aid. Legal aid is part of the court system and part of the Department of Justice. And it is a branch where they only do mediation to people who with low income. And they offer it to them as part of they engage a lawyer, the lawyers get paid by the legal aid, but as part of that, they are mandated to go to mediation first. And through that mediation, they resolve most of their conflicts, and they have very high rate of success as well. So there are other there. There's a third system in place in Australia, as I mentioned earlier, that the federal government has funded organization and institution to offer low-cost mediation in the Family Law Act, under the Family Law Act, which is divorce and related issues to divorce. So what they do is if someone earns $100 a week, they ask them to pay $2. It's not, they don't ask them to pay the full amount. And the government subsidizes the rest. So that's how they then encourage people to go for mediation. And because under the Family Law Act, mediation is compulsory and mandatory, then these institutions and the organization that provide the service, they do the mediation on behalf of the family law court. Again, it really reduces the time that people spend in court. Currently in Australia, the family law court is very slow because of so many cases, litigations, and they are working hard to reduce it even further, to reduce the number of cases before the courts. And they are the sort of areas, and you can see that those services are available for people who normally would not have been able to go through the court system in some cases. And if they have gone through the court system, they would have to wait for many years before their turn comes to be heard, their cases. And there is a big acceptance by the public and the lawyers. And actually, I worked with the legal aid for a while, and I have lawyers in the room who are actually assisting in the mediation with their clients. And that's how they are actually for mediation. And they are encouraged their clients to go for mediation because it's easier, quicker, and less painful than waiting in court, not knowing what the outcome in court. The public has accepted mediation as a better option to litigation for many reasons. Namely, it is fast, efficient, empowering, convenient, and free. Mediation in Australia is the most widely used primarily because it delivers a win-win outcome in a very short time. It is no surprise that 85% of the cases referred for mediations are resolved, while it's under 60% of cases are resolved in courts to the satisfaction of all parties. It is further noted that agreements reached in mediation are adhered to by the parties, and this is considering the agreements are not legally binding. They are in mediation. They can be done legally binding, but they are kept because the parties feel they negotiated that agreement, they've accepted the terms of that agreement, and they own it. So they are more likely to adhere to it and keep it rather than being ordered to something that they don't like. And in court, it's one loses, one wins. And the loser will always be upset and angry and all of that. And the winner may have already cost them so much money to get that win. So they both are losers in one way or another. So that's why the public accepted mediation as a way of resolving their conflicts. The benefits of mediation are the main reasons for it being widely accepted. by Australians. Some of the benefits are, which I said earlier, it's a low cost, it is fast, it's happened within a day and finished in a day. It's confidential, it's empowering to the parties because they negotiate their own agreement. It's not imposed on them. Outcomes owned by the parties. They participated and negotiated that agreement. Parties preserve or commence in new relationships. Parties able to express their feelings, which they cannot do that in court. Parties deal with the issues directly with each other in a safe space. So they're not talking through lawyers and other third parties. They get across to the court. It is informal, flexible. The dispute is owned by all parties present, and parties determine the outcome. So there are so many benefits to mediation, to community mediation, and that's why it is widely accepted by all parties or by the public. The early years of mediation in Australia witnessed many enter the profession without formal training or qualifications. For a period of time in Australia, anybody could call themselves a mediator without even having any training or knowledge of mediation. They just think because they can talk between the parties, they can call themselves mediators. And that was quite concerning to many in the profession. It's like someone calling themselves a lawyer or a doctor without having the qualification. It is concerning because that will cast doubt about the integrity and the respect of the mediators and its profession. And then at that time, there was a lot of talk about how we can deal with this situation. It was not acceptable and did not help give a professional image about mediation at the time. In the early 90s, a new code of practice under the National Mediator Accreditation standards was introduced and established and was accepted widely. Under the accreditation standards, they are setting conditions about who can be a mediator and who cannot be a mediator. They need to go through a system. They regulate the appointment of mediators and monitors their performance. It's not about appointing a mediator, they are monitored. The code also introduced strict training requirements and ongoing learning and professional development right through the times they are practicing. The code further established accreditation bodies who are authorized to accredit newly trained mediators. Any course we teach about mediation, it has to be an accredited course. And after that, they have to go to an accredited body to sit for an assessment test. And they have to pass that. And once they pass that, then they are appointed or accredited as a mediator for 2 years. And every 2 years, every person who is a mediator in Australia have to go through re-accreditation. And they have to show that during the last 2 years, they have done X amount of hours in the training and development, attending conferences or workshops or some other development practice, as well as they're going to show how many hours they have mediated. There's a minimum hours. If they have done no mediation at all, then they cannot be accredited. So they need to be able to have up-to-date knowledge and experience in the job. So it is very strict, and it is for the benefit of all the mediators. All mediators as well, who are working for themselves, private, they must have insurance, professional indemnity insurance. It's not very expensive. It's about $200, $300 a year, but it does cover $20 million in case there is an accidental incident happened during mediation, to cover the parties and to ensure that they are receiving whatever support they need, medical or otherwise. If there was a fight or there was something else, or the mediator did not pay attention to their safety or did not do the right thing. So that insurance covers any loss in that aspect. Mediation practice is further enhanced by the Australian universities and education institutions by introducing mediation as a course subject in law schools, as well as when I was teaching for the last 12 years at the University of Sydney. It was part of the master degree in international relationship and international relations, as well as in masters in public administration, and masters on peace and conflict studies, and also in other schools. And the reason for this, it's most of the people who sat for my course, they did not intend to be mediators. They're mostly senior public servants. And what they do, the skills of mediation, the skills of mediator are important. And if every job advertised in Australia, you will find conflict resolution as a criteria for applications, for the applicant. They have to have knowledge of conflict resolution, on how to manage conflict in the workplace. Every senior officer in any department or any company, they need to have that skill. So it's important. That's why they take the course, and was very popular with most of those group of people. Mediation is not limited to resolving conflicts with the assistance of trained mediator. Conflict resolution skills are now a requirement in every senior management position in the private sector as well as in the government jobs. Applicants' ability to identify and resolve conflicts in the workplace is a requirement. The University of Sydney introduced mediation, and that's what I was talking about earlier. And it's something that I was the initiator of the course by suggesting to the university to accept it as a course, and that's how it written it and accepted. Dispute resolution skills are also taught in the schools under the peer mediation program. It is seen that children or school students are the best people to solve their problems. You don't need an adult like me going to the school and telling children how to behave. They will not accept it from an authority, but a child, a student to student, they will understand each other better, and they are more successful in resolving the schoolyard disputes than having a teacher or an adult telling them how they should behave. And it's been very successful program. The New South Wales Law Society has been doing every year mediation competition between the schools, and the schools take it seriously. I was a judge in one of those competitions, and it is extremely high quality. The students are really put their heart into it, and they really do it with passion. So it is important that you do that, and it is something that we teach our kids how to resolve their conflicts when they're young. As they grow, you'll find that they take that with them. It's not the same as a subject in history or geography, where most of us don't remember 10% of it after we finish school. But this skill, it goes with them at every stage of their lives. And that's why we encourage them to learn about that. The program further provides students with alternative resolving disputes, not only in the school, but at home as well, or in the street outside the school. And they actually teach their parents as well the language of dispute resolution, the language of mediation. So they actually take it with them. It's really important that we do. I conclude my talk by saying that mediation and conflict resolution skills are essential to all of us. We all experience challenges and conflicts in our daily life. Most conflicts are caused by the language we use. Conflict resolution is about communication. The way we communicate our grievances and complaints determine the outcome. If we are positive in our communications, we are most likely to achieve a positive outcome and mediation and maintain a better relationship with the other people. Thank you.
Thank you, Abe. Now the floor is open for questions. There's also already one question put up in the chat box. And this is a question from Dhanya. She has asked, may I know the proper procedure to become a mediator? To some extent, Abe, you had covered this topic when you spoke about the accreditation system under the code of practice. But perhaps because this question has come up, maybe you could speak about, what is the eligibility to be a mediator? What is the prior experience they require, and so on?
Thank you. There are two parts to systems. There's one general practitioner as a mediator, and there is one accredited under the Family Dispute Resolution Practitioner, which is the Family Law Act. To work in divorce cases and family law cases, you have to be accredited as a family dispute resolution practitioner. And that takes about 1 week in university course full-time. There are other institutions who offer the course, and that takes longer. Sometimes it takes up to 9 months part-time. The general practitioner that can work in any dispute, either neighborhood, community, or workplace, or commercial, that they do a course of about 1 week full-time. The course in itself is an accredited course. However, they need to go and sit for an assessment. They role play, they play as a mediator in role play, and there are two steps assessment. One assessment in the room, and then the whole session is recorded for a second opinion from another assessment. And there is a criteria on what things that they have to be fulfilled or met by the mediator for managing the process, the language, the procedures, all this, or the type of questions asked, all of that comes into the assessment. It is 1.5 hours role play, and if they pass the test and the assessment, they are then accredited for 2 years. The family dispute resolution practitioner are accredited for life. Once you pass the test, you are accredited. However, you need to show every now and then the people from the registration office, they will call you and say, okay, how many mediations have you done in the past 12 months? What training have you done, or training and development? What other things you have done to maintain your accreditation? So you need to give them that information. And it can be every year, or it can be, they might call every 5 years, but you never know when they call you. And they keep you up to date by sending you emails about up to date of the changes in the law or changes in the system or whatever. So you are kept up to date with that. So that's the two accreditation.
Mehernosh Shapurji has a couple of questions about community mediation and another question. Mehernosh, please go ahead and ask your questions. Mehernosh, are you there?
Yes, I am. Thank you.
Yes, sir, yes.
Okay, I wanted to know, thank you for that information that you shared with us. Two questions really. The first was to do with community mediation. So what are the kind of cases you get in community mediation? And related to that, I wanted to know, have any class action cases been resolved through mediation?
Yes. Community mediation, neighborhood disputes, okay, between two neighbors. It could be about noise, about what fence to have, how to change the fence between them. For instance, it could be the dog barking. It could be anything, which normally police would have responded to those cases. And not only once, could be many times because it keep coming. So that one area. The other community dispute is between the customers and the shops, the businesses. Or someone come, you ask the tradespeople to come to your house to do a job and you're not happy. And they want the money, you can't pay the money because they're not done the job right. So that's a dispute that we deal with. Workplace disputes as well. That's not under the committee, but it is part of it. Between children and their parents, or members of the family, or friends. So that sort of disputes we do. About the class action, I did one dispute where I had 37 households against a developer, building developer. This building, they got a council approval to build 8-story building in this residential area. And the whole community there protested because the protest for the noise, it's going to generate while building, the dust and all of that, the trucks and the cars that are going to come into the area for the whole time, plus because of the height of the building is going to cast shadow, and the sun not being on certain parts of the houses, all of that sort of thing, plus their privacy, where people can look into their backyards. So all the sort of issues were brought to the attention of the developer. Okay, the developer did not have to do anything because they got approval. However, for them to really gain, because they don't want to have hostile community, they cannot sell the units afterwards. If there's hostile community, nobody wants to buy something that is already being rejected by the local community. So they met, and I worked with the two other mediators to resolve that conflict. And we resolved it to the satisfaction of both the builder as well as the people there, and with some modifications and certain areas that they need to take. So it was successful in that way.
There are a couple of more questions from Amarjot Bajaj and from Dhanya. So Amarjot, you can please feel free to go ahead and ask your question.
Good evening, sir. This is Amarjot from Gurgaon. And I just need to know, sir, it was a very informative session. Of course, thanks a lot for it, for sharing your information. My regard for is it that how are the freshers entered into the, accepted into the mediation concept, the race for that, and what are the different openings that they get it after, becoming a mediator? Thank you.
In terms of the acceptance by the community, you mean, or by...
No, acceptance by the mediators group of association, Like
Mhm.
how they can enter into the world, once they finish into it, how can they enter into
Yes,
the mediation world,
yes.
to
Uh,
work for it, whether it is in a community setup or in a family setup, or what are the different scope of their opening for the work, How
okay.
do they start it off,
So about the opportunities and what opportunities there are for
Yeah,
mediators to
that's
start.
right.
There are many different ways. Most lawyers, houses, big firms as well as small firms, they have mediators. If not the solicitors themselves, they have mediators who work with them in the same office. We have Community Justice Center. They have mediators there, work for them. We have also the government-funded bodies, small institutions and NGOs who offer mediation, and they get paid for it. Or you can work on your own by advertising. So there are opportunities there. There is a body, we have the Resolution Institute here, a body that you can join as a member, and they advertise yourself within that organization. And people normally, if they want a mediator and they don't know one, they go through the Resolution Institute and ask, okay, I'm looking for a mediator who is skilled in this type of mediation and who lives in this area. So they give them information about and sort of match them. So you get jobs through them. And plus, mediation is not about resolving conflicts alone. There's many different things a mediator can do. And part of that is about coaching, conflict coaching, or about running workshops for people how to identify conflict and how to avoid it, how to see conflict before it happens, or early days of it, in organization, in groups, in businesses, in government departments, all of that. So there are ways of doing. And plus you can, if you have experience enough, you can go into training. I trained the police officers in Sydney, 60 police officers, because they wanted to have the skills of mediation. So I trained them. And this is the sort of work you do. There's many different ways. And it is up to your imagination how to use your skills. There's peace building and how to educate people in conflict. So it is really, it's wide. And we don't just limit ourselves to just being a mediator, resolving conflicts alone. Okay.
This evening,
Thank you, sir. Thank you.
Thank you.
we have in Mr. J.P. Singh, who's a senior mediator and trainer from the Supreme Court. J.P. Singh, sir, are you there?
Yes.
Okay.
Yes.
Yes, so would you like to ask any question? Or
I find it very interesting. When you say that, you started this movement in '83, and we did today in 2021, if you still offer free services and free for especially community and other mediations, do you ever see this becoming an alternate to the court litigation? Because you have also burgeoning court litigation, as you said. You said that Australians are litigators. So
Yep.
that being so, do you ever see this? Mediation becoming an alternate to the court system?
Yes, it is already. It's not complete. We still need the courts. However, we become more selective on what matters go to court and what matters go to mediation. So it is a matter of selection rather than send everything to the court or everything to mediation, because there are matters not suitable for mediation. And there are some people want to go to court believing that they can get better outcome in court, or because of personality. They may just want to go unpunished. They don't want to make relationship. So there are many different reasons why people still want to go for litigation rather than going for mediation. So it's a matter of choice, but the courts, the lawyers are all for mediation.
But do you think I can make my living through mediation?
Absolutely.
It's
Absolutely. It depends on you and how imaginative you are, like any business. Some businesses fail, some businesses flourish. How you manage yourself, your network, if you are well known and all of that, you become known. You build your business slowly and you become more, people can see. And mediation is very fast moving industry. I mean,
that's very interesting.
Yeah,
I have one more thing. For community mediation, do you need any special skills? I mean, now that
you need to be accredited.
No, in terms of mediation skills. In terms of mediation skills.
Yeah, all mediators need to go through the same. A friend of mine, he's a lawyer and he's a barrister. And recently, about 3 years ago, he decided to become mediator. He reduced his work as lawyer, and now he is practicing mediation full time, basically. So he sees there's benefit for mediation rather than for being a barrister. And he's well known in a very skilled barrister. But he now moved into mediation, and he's not alone. Most of my lawyers friends have moved into mediation. And that tells you there is money in mediation and there's work in mediation. It's not that the people can't live from. There are people, I know people are really very busy. It's a matter of choice.
That's very interesting. Thank you so much.
Thank you.
Any other questions? Abe, I myself have a question.
Yes, please.
I want to broach a topic. Could you speak a bit about your work with people from conflict-ridden communities in Sri Lanka, Rwanda, etc.? What is the work you do?
Okay. What happened here? When people flee conflict and migrate to other countries, the conflict does not stay back home. They come with the conflict. They take the conflict with them. And Australia being multicultural country with 180 different nationalities, different cultures. Can you imagine with all the many people who escape conflict and come here and fight their conflict here? So what we did, I worked with the Sri Lankan reconciliation group, which is made up of Tamils as well as Lankan. And they wanted to see the leadership. They asked me to do workshops for them on how to live with conflict. I'm not asking them, forget the conflict, never happened, but yes, it happened. How we live with it without having to fight each other. So the workshop is about peace building, and I called it reconnecting communities that is being savaged by the war and the conflict and the fighting that happened back home. When they come here, we don't want them to live the trauma, but we want them as well to adjust to a new environment in a peaceful way and deal with that conflict in a positive way. It's a choice we make. Either I deal with it in a negative way and hate everybody, or I deal positive and say everybody is the same as me, victim. We're all victims of the war, regardless which side you are in. And that's how we work with them. And they are very successful group. The same thing with Rwanda. When I met with the Rwandan people, as you know, the massacres and that happened there, and we talked about it. And that's how we run the workshops for them. And we brought actually the Rwandan, the Congolese, all those sort of the Great Lakes together. And we run the workshops and we talk about their experience, how it happened, why it happened, get them to understand it, and then relate to each other. How they relate to each other, because they all live the same experience. It doesn't matter which side you are in. So it is important. And that's really about it. And then the other group, I was involved with the Palestinian Jewish group as well. It's really about having, there's an image there that Palestinian and Jewish will always fight and they will always hate each other. And that's not true. Maybe the government policies makes that true, but the people themselves can live together and can be friends. So I gathered a few Palestinian and Jewish, and we sat together and we talked, and they said, why should I hate you? What have you done to me? And this is how we started the dialogue. And it's now 14 years since started. And it's been really great. So it is really all of those sort of things. We can live with conflict. It's not conflict. We cannot say conflict is bad. Conflict is really an alarm, a warning to tell us, if I do something about it, it will get out of hand. So it's an opportunity for us to adjust and do things differently.
Thank you, Abe. So it was interesting to listen to you, and I wish you could go on and on because we would like to hear so much about your experiences. But we have come to the close of the allotted time, so I request my friend Ramamani to now propose the vote of thanks.
Gratitude is the sign of noble souls. I would like to express our sincere thanks to Mr.Abe Quadan, accredited mediator, Sydney, Australia, for giving his excellent coverage about mediation. We are all inspired by your great words, sir. We are fascinated as we listen to the captivity and insightful words of the speaker who had such an accurate understanding about mediation. And this analytical speech about progress and achievement of the mediation in Australia is very informative and enlightening. So, and once again, I thank you one and all who participated in this forum. Thank you.